and he pleads not guilty. And they say, how could he have pled not guilty? There's so much evidence against him.
Now, new developments in the murder of a young woman on a popular hiking trail up near the Mayo Clinic. 29-year-old Lauren Heike was ambushed and killed a few weeks ago, and the suspect in the case pleaded not guilty today in court.
Detectives say they have a DNA match and caught him on camera running away from the scene. Sarah Robinson caught up with an attorney who's familiar with the case. Such convincing evidence, but it's not uncommon for suspects like this to plead not guilty.
Correct. It's not uncommon. In fact, this was pretty expected today. This is a standard move for an arraignment hearing. And the one main reason, it's still very early on in the process.
In criminal cases, there is an exchange of discovery. So what happens is the prosecutor's office is required to turn over all of their evidence to the defense. And usually the defense is going to review all of that evidence before they start negotiating plea agreements.
Russ Richelsoph, an attorney with the Davis Miles law firm, says since the murder is so recent, it's likely police and crime labs are still in the process of finding more evidence against Teasley. So a not guilty plea is to be expected throughout this phase.
And really kind of the same thing happened when we're talking about that criminology PhD student who killed those 4 Idaho college students. DNA there as well. He also pleaded not guilty.
This is essentially exactly the same thing that we saw yesterday with Brian Kohberger. Richelsoph says it's important to remember that in any case, no matter the evidence against them throughout this phase, it's very standard that they will enter not guilty because it takes a while for them to discover all of the evidence and then develop a case. So they have that right to not guilty in agreement.
If you were to look even with the Kohberger case, he stayed silent for the plea portion, and the judge still entered a not guilty on his behalf. So really the arraignment, the purpose of the arraignment is not for the defendant to admit their guilt or deny their guilt. It's really a procedural hearing.
Even if a defendant wanted to admit their guilt during an arraignment, Richelsoph says a judge would not allow it.
The court wants to make sure that the defendant's constitutional rights are protected. They want to make sure that if the defendant is convicted of a crime, that conviction will hold up to, any potential appeals. The court doesn't want there to be an error made in the case.
And Sarah, as far as a timeline, when might we see a plea deal in this case if one is put out on the table?
It's hard to say, but we now know that the next step in this process is likely finding out if the state will file a notice of intent to seek the death penalty. And if that happens, it would be in the next few weeks.
Okay, we'll be watching it closely. Thank you for that, Sarah.